we want to welcome everyone, and we have our other leader, Brother Andre Chapman, President and CEO and founder of Unity Care, who will be facilitating a conversation with Judge Cordell. And so with that being said, we're going to ask for you all, there will be a time where you will be able to make comments, and we will have breakout groups. The agenda is in the chat box, so if you are on a computer, you can see that, and we'll do our best to stick close to the time. That being said, I give you in the hands of Andre Chapman.
Well, welcome everybody, and looking forward to this great conversation with Judge Cordell. I want to just begin by saying, Judge Cordell, it's truly an honor, no pun intended, to moderate this dialogue about your amazing book. I'm one of your biggest fans, and not because you've had this phenomenal career and you're the first African-American female Superior Court judge in Northern California, but really because I first met you when I was in high school. I was a junior at Gun High in Palo Alto, and you came and spoke to our Black student body, which was a very small number, about your practice in East Palo Alto and about going to law school, but continuing our education. And it had a profound impact on me and my life and the work that I do and my interest in the legal system. And then as a student at San Jose State in my criminology class, and can't remember the year, maybe 1983, I came and I watched you when you were a Superior Court judge. But before we jump into the book, I want to
wait a minute. I gotta jump in and just say to you, Andre, thank you for engaging me in conversation. And I want to take full credit for the fact that you are one of the leaders of Santa Clara County. I'll take full credit for it. So thank you so much. Thank you.
All right. Well, before we jump into the book, I just want to pause for a moment in the ALF way and do a check-in. And this check-in is really coming from the community to you. And it's acknowledging your courage and your fortitude to write this book. The many battles you face, the racism, the personal attacks, the pressures, the constant weight of being Black in these white spaces, and the pressures of being a Black woman in these male spaces. So we honor you by bringing you this opportunity of allowing us to come into the bedroom of the judiciary system, really through your pain, trauma, your joy, your celebrations, and really give you back your power and your space to heal. And I just want to start with that before we jump into the first question. So let's jump into the first question. So what motivated you to write this tell-all book, and how were you able to have such an impeccable recall over your entire time on the bench?
Her Honor is what I call a primoire. It's part primer about our legal system and part memoir about my experiences on the bench. So I never thought about writing a book about judging when I was on the bench. What I did write, though, were letters to my parents. And I think we have an image of my parents. I wrote letters to my parents every Friday about the last 7 or 8 years that I was on the bench. And I wrote them because they loved hearing about all the cases I presided over. And the letters didn't just detail the cases. I also wrote about how I felt about this. These were very private letters. And Andre, I'm not talking emails, I'm talking letters, like letter writing with the postage stamp on the envelope. And I think it's an art that we've gotten away from that I hope people can get back to if we're not already letter writers. People love to get letters. I think it's important. So I wrote these letters, you can imagine, for 7 years every Friday. And I picked Fridays because Friday afternoons, the courts, generally there weren't cases going in the afternoons because we were preparing for the cases for Monday. So after I retired, I went back east to just outside of Philadelphia, where I grew up, to visit my parents. And at some point, my mother, who was very organized, pulled this box out of the closet. And she said, "What do you want me to do with all of these?" And I looked in this box, and my mother had saved all of the letters. Now, understand, I had not made copies of these letters. I'm just writing to my parents. There's no agenda other than to fill them in. So I packed them up and sent them back here. And there they sat in a box for about 2 or 3 years until I decided one day, well, let me take a look at these letters. And I started reading them, and I was stunned by how many cases I had presided over and the wide variety of cases over which I presided. So I started to get then an idea, well, maybe what should I do with these letters? And that's when the idea started about writing a book. And then the final thing, the thing that pushed me to actually get started was, and something that happened in Santa Clara County, and it had to deal with the recall of Aaron Persky that I write about in the book. And I was outspoken against the recall because I believe it was a threat, and it was a threat to judicial independence. But about the book, it was that I interacted with a very educated electorate here in Santa Clara County, and I was shocked by how little people knew about what trial judges do, about the legal system, and about judicial independence. When I would raise that term, I'd either get, well, what is that? Or I'd hear, well, that's just a cover for judges. They're just closing the wagons, and that's all that is. So I was really shocked by that and decided I need to write a book that informs people, I hope in an entertaining way, about the legal system. And to assure there's credibility, I wrote about my own experiences.
Well, as you said, in an entertaining way, it was both humor, some sadness, some frustration. So you covered a variety of different feelings that I took from reading the book. What have you learned from this process?
Well, first of all, I didn't know that I could write. So I could write legal briefs, but I'd never just written from the heart about things other than letters to my parents. So I learned that with some discipline and determination and motivation, just about anybody can write. I really believe that. This process took me 1 year where I had to be very disciplined. I think you can't undertake, if anyone is interested in writing a book, the process is one where you have to be very disciplined. And so I wrote 4 to 5 hours every day for a year. And my writing time was in the afternoons. Mornings, I have to get exercise, and then I'd sit from noon to 5 or 1 to 6 and just write. So what I learned from this process is that if you want to write about, especially a memoir, you have to be brutally honest. And as you noted in the book, I write I wasn't perfect. I didn't do things always the right way. I didn't feel good about some of the things that I had to do on the bench. But that's part of the whole experience of being a judge. So I've learned now, since the book has been out, that people indeed are interested in this subject matter. And I've heard back from people who have been very moved by what I've written. I've heard back from judges, I've heard from lawyers, and from non-legal people at all, who would say to me, I had no idea that, oh, you judges, you have feelings.
Yeah.
You have feelings. And so it's been a wonderful experience. Writing's not easy, but I'm pleased with how this all came out, and with whom I work, which are these wonderful publishers at Celadon, which is an imprint of Macmillan. They have been fantastic in editing and in working with me in this process.
Wow, that's great. Well, let's talk about your very first case. It was somewhat of an anomaly. 2 Black women as a plaintiff and as a defendant about hair. And there was a comment that you made. You wrote, hair for Black folks, especially Black women, is as important as the air we breathe. And I also noticed something very unique about your book, as you actually credited your hairstylist. So tell us about this issue of Black hair, and why did you decide to credit your hairstylist? I don't know if I've ever seen that before.
You haven't. I will tell you that. Nobody has. So this first case, and I write about it in the first chapter called Bitten by the Judge Bug, was before I became a judge. It's because of that case is when I decided that I wanted to try to get a judgeship. I got a random phone call from a man named Mark Thomas. I did not know him. And he's a judge on the municipal court at the time. So we're talking 1980-ish. And he called me. I was the assistant dean at Stanford Law School. And he said, look, we have a judge pro tem program in Santa Clara County. Pro tem from the Latin meaning for the time. And what it meant was a lawyer could be a judge for a day and preside over a small claims case. Small claims cases are what Judge Judy presides over. These are where lawyers aren't allowed and people are suing each other over a limited amount of money. So he said, I want to diversify this list, people who are on the list to be pro tem judges. I want women, people of color. That's why I'm calling you. Can I put you on the list? So I thought, sure, fine, put me on the list, and didn't think anymore about it. So then a couple of, I don't know, months later, I get this phone call. It's from the court in Sunnyvale saying, your name has come up on the list. Your date is this date. Do you want to still come and be a pro tem judge? And I go, sure, what the hell, fine. So on the appointed day, this was the afternoon, I drive down, I get a robe, put it on, and I walk in the courtroom. And as you just described, Andre, I walk in, and the only people in the courtroom, because this is just one case, no spectators, are two Black women, one suing the other. And one was suing the other over her hair. And basically, one was the hairstylist, and the other was the person who got her hair done. And she didn't want to pay the hairstylist because she did not like the way the hairstylist had braided her hair. So I'm going to leave a teaser as to what happened at that hearing and what I decided. But I will say that as I was driving home, I decided I like this. I really like making decisions when people can't work things out themselves. So hair. So I write about that in the first chapter of the book, and I write a little more about hair, about how my two sisters and I, when we were growing up, my mother did our hair, and we had, really straightened our hair in tight braids and had ribbons tied on them if it was Sunday. And I also write about Rabia, who is my hairstylist and who just saw me all through my time on the bench. There is an image that I hope you can show. I don't see the one go up of my parents. And then there's an image of all of the hairstyles that I wore during the time I was on the bench. I mean, 20 years, that's a lot of different hairstyles.
I remember the afro.
So I hope we can get that up. The afro didn't come till much, much, much later. There's my parents. So that's, my mother's name was Clara. My father's name was Louis and Clara Hazzard, and they're the ones who saved it. And this is an image of my being right before I was sworn in 1982, becoming the first Black woman judge in all of Northern California. My two daughters are pictured there, are now in their 40s. And my parents are no longer with us. They died a short while ago. And there I am being sworn in by Thelton Henderson to begin my journey in 1982. So to get back to the hair, there we go. So I started at the very bottom in the middle. It's a color photo, and the hair is straightened and flipped up so I can fling my hair. You see that? And then it gets a little shorter, the one on the left. And that's when I was first on the Superior Court, 1988. And then you can see how it changes. I had dreads there's one corner, then I had a box with a fade, and then the short fro, that's just a very short cut. So hair, I write in the first chapter, was very important. It's an important part of my being, and no small measure when I would go out on the bench, because there'd never been a Black woman judge before. And there was not the proliferation of judges you see on TV now. I mean, it's no big deal, but back then there weren't any. So I'd get a lot of frowns, smiles, double takes when I would come out, depending upon, of course, it didn't even matter what hairstyle I had. So Andre, you mentioned the back flap of the book. So if you buy the book, if you have the book, you'll see on the inside back flap, there are always credits for the book design, the design of the cover, and also the photograph, if there's a photograph on the cover. And that's it. That's what it's standard in the book industry. I asked my editor, my publisher, if we could also have a credit for my hair, for the haircut that I had that shows on the front of the book. And I don't know if you can put the book cover up now, Kemi. And I was told initially that that's not done in the book industry. You only give credits for the design and a photograph. That hair credits are given in magazines. So I pushed back a little bit. We had a big, fuller conversation. I have such a wonderful editor who's finally said, yeah, why not? So I believe Her Honor is the first book in all of the book world ever where there's been a credit for hair. And you will see Rabia Zara's name, giving me a credit for her having cut my hair for the photo. Story, the lesson learned is, let's, think outside the box. Think outside the box. And that's what Black folks have had to do since the very beginning. Always had to think outside the box, find a way where there is no way.
Yeah. And I also, the statement that you that was in that same part where you're talking about this is if this case had been assigned to one of the judges on the court, it would have landed with a white male judge clueless about roots, braids, cornrows, and matted hair. So I think you also drew the correlation to being culturally proficient and making sure there's folks on the bench that look like the people that are coming forward. So I really appreciated that.
Exactly. That is why it is so important that we have a diverse judiciary, that we have people from different backgrounds. The fight is still on. We have more diversity, but we still have a long way to go.
Well, let's jump to a couple of your, and I think I was a little bit surprised by how many different courts that you presided over: family court, probate court, criminal court, juvenile dependency court, small claims court, traffic court. So let's discuss foster care, especially as 59% of all adoptions come from foster care. And you wrote that annually more than 400,000 children in our foster care system, approximately 114,000 who cannot be returned to families, await adoption. Nearly 20,000 are never adopted every year. You describe a painful journey of Irene Young, and you stated the system's gravest failure was in terminating the parental rights of Irene Young's mother before finding a permanent home. This case resonated with me because obviously over the past 28 years running Unity Care, serving youth in foster care, I've seen thousands of Irenes that are lost in the system, failed adoptions, terminations, parental rights, no connection to their family. But really stuck out to me, Judge, was that there was really not a mention of Irene's African-American father, the paternal side of the family, which is oftentimes a common thing within child welfare. So what do you think the system should have done different in this case?
Sure. There's a chapter in the book called Would You Be Mine? And it's about adoptions. I did preside over adoptions for 2 years on the court. And for the most part, it's a happy occasion. You're making families, you're creating families, and you're mostly giving children homes. I mean, there are all kinds of adoptions. There are adult adoptions, step-parent adoptions, but the ones that people are most familiar with are the individual adoptions or called stranger adoptions, where usually a child who's not related, of course, is brought into a family. You mentioned the case of Irene. I don't give her last name. In fact, I changed her name for privacy purposes. But this was a case that was so traumatizing, not just to her, but to me and everybody involved in the system, because I had to set aside her adoption. This child had been abandoned, then adopted, and she's biracial, adopted by a Black woman. And it turned out that this child had been so damaged in this process that this Black woman was literally in fear of her own safety and life. And I had to set aside the adoption. So now I had to tell this child she was being abandoned again. So you asked what went wrong? What should the system have done? And I do call the various agencies and departments out in this book when I talk about it. This child was the product of a child. Now, her mom was very young when she had her, and the two of them moved from foster home to foster home until such time as the social services department decided it was appropriate to separate them, primarily because Irene's mom had been molested. So they separate them, put them, which was a travesty. And so they just stayed apart, and they were that link was gone. No effort was ever made to identify the father. And she just kind of languished in the system until she was adopted by this Black woman, who then I had to set aside the adoption. So the problem in this one case was that they terminated, this is the Department of Social Services recommended, and a judge, not me, terminated the parental rights of Irene's mother. That's the only person she knew in the system. So they terminated her rights without before placing her with either a relative, a family member, or anyone. So this child was just loose in the system with no parent at all. So when I had to set aside the adoption, she was, again, just completely alone. This should never have happened. Additionally, social services never informed the adoptive mother, the Black woman, of the behavioral, basic emotional issues this child had. So as a result of all of that, the adoptive mother really didn't have the full information and likely would not have stepped in to adopt.
Well, Your Honor, this book was calling out folks. I mean, you call folks on the carpet, and I think that oftentimes we work in institutions, we work in systems where we don't feel that we have the ability to speak up, or we're afraid to speak up, or we feel we're handcuffed to speak up. And so that's what I really appreciate about the book, because it was very transparent. You were very clear about where things that were broken that can be fixed, and you're also very clear about challenges that you faced, sitting from your judgeship. I want to jump to the three strikes. That was another area, and you wrote, only 2 years after California voted for the three strikes law, African Americans made up 43% of the third strike defendants, imprisoned at more than 13 times the rate of whites. What I'm sure was surprising to many in Santa Clara County is that Santa Clara County was the worst in the state, with the highest disproportionality of Blacks making up only 2.7%, but 27% of the three striker populations. That's 10 times the general population. I also draw a parallel to foster care, because we see those same double-digit numbers around disparity right here in Silicon Valley, the land and the world of innovation and opportunities, but our disproportionality is worse than some states in the South. Why do you think that's the case?
So race has always been the elephant in the courtroom. Everybody's, ever since the beginning, tiptoed around it. It's always been there. Racism is baked into the legal system in America. And so since primarily the Black Lives Matter movement and the murder of George Floyd, the elephant, they're not tiptoeing around the elephant anymore. People are calling it out. And in the book, I write about how I attempted to address race in the courtroom. But again, this is in the 1990s, when judges, prosecutors didn't want to hear it. And I write about how, indeed, I was shut down and pushed back on it. I also write about the conflict that I experienced in being the only Black judge on a bench that had all of these people of color, Black and brown, so many of them landing in my courtroom, where I had to uphold this draconian three strikes law and sentence these folks to life in prison when I didn't want to do it. So why did I do it? Well, judges take an oath to uphold all the laws, not the laws that the only ones that we like. It's all of them. But there's a passage in the book that and it's very short, that I write about the conflict. And I just like to read that to you. And
Absolutely.
I think it's on, here we are. And it's on page 254. And I write the following. And my tenure on the criminal court bench was a conflicted one. By simply donning my robe, I knew that I lent legitimacy to a system that disproportionately targeted people of color. The majority of cases over which I presided involved defendants who looked like me. My presence on the bench gave defendants of color hope that they would be seen not as a bunch of gangbangers, thugs, and drug addicts, but as human beings. And it would allow for the possibility that many, perhaps most, were better than the worst crimes they had ever committed. One of my life's sad recognitions is that it is far easier to understand the humanity of even the most egregious of offenders when that person resembles you, less so when she does not. So with that conflict, you talk about the three strikes law. When those cases came before me, I had to uphold the law, but that didn't mean I didn't try to find ways to not enforce it when I felt it was not right to enforce it. And sometimes I was successful and sometimes I was not. And I write in the book about the time that I was not, and which really led me to say, I've had enough. I can't do this anymore. And it's the case of Leo Hill. And another teaser, it's just, I wrote very frankly about that case and what it was I did, how I felt about what I did. And then there's a follow-up to what happened to Leo Hill.
Well, I think that the thing that stands out for me in reading this book is your transparency about how you felt, because I know the pressure, or I can only imagine the pressure you have had to have felt as being the judge, making life critical decisions, but then also being boxed in by the racist policies and laws that constrict to what you can do. So I can feel the pain in the reading when I was reading some of these passages.
You know, Andre, I have been contacted by a number of people who've read the book, and one of them is a sitting judge in LA. He was a brother, and he called me and he just said, I read this book, and he says, I'm keeping it right here in my chambers because what you described back when you were on the bench is exactly what I'm dealing with now. So the struggle continues.
Sure.
And I now know it was important for me to write exactly about how I felt about those pressures and the tensions. But I don't want people to think that, judging was just one big, huge, heavy burden. It wasn't. It was the passion of my life. It was the joy of my life. Yes, I had some god awful days, but I had some wonderful days as well.
Absolutely. I had spoke to, just in the last 2 days, 3 separate folks about your book, and all of them have had personal experiences in front of you. And the common theme was that you spoke to them directly about, whatever their situation was. You were you connected to them. They trusted the words that you said, and that they knew that you were there for their best interests. And so
That's
that
nice
is
to
a
hear.
testament to what also comes very forward in the book.
That was nice to hear. I do want to say that can I just give one quick anecdote about someone
Absolutely.
else who was in my court? So I'm parked outside grocery outlet in Palo Alto. I get in my car, I'm ready to go. And there's a car next to me, and there's a brother sitting in the passenger seat. He rolls down the window and says, "Are you Judge Cordell?" So I rolled down mine. I said, "Yeah, yeah." And he said, "I was in your court." And it was clearly back in the early 1990s. And and he said, you were very fair to me, and you gave me time served, whatever it was. So can I get your book? And I said, "Well, yeah, you can buy the book." He says, "Well, you don't have any books in your car?" And I go, "No, I don't have any books." He says, "You should be selling them out your trunk. You can make a lot of money, sell them out your trunk. You should." And I'm like, "Okay, all right." So, I drive off, and as I drive off, he's behind me. The driver gets in the car and he just yells, sell them out your trunk. And I'm laughing about it, right? But think about it. That's really Black economics. I mean, if you
Absolutely.
go to Philly, New York, or wherever, Black folks, we're selling stuff right on the street, out the trunk. So I get what he was saying, and no, I'm not selling them out of my trunk yet.
hmm That's how a lot, FUBU, I mean, Damon John, if you can go
That's
down the
right.
list and see folks. So I know that for the interest of time, I do have 2 more questions, but I do
Okay.
want to pop back to the conversation you mentioned earlier about Judge Persky. And you said yourself, you were the most vocal of the judges' surrogates against the recall. And you also talked about the California Canon 3 bill prohibition on public comment that muzzled Judge Persky from saying anything. Do you think that if he was able to respond, that would have changed the public's opinion or staged off any recall about what happened?
Yes, Andre, I do think things would have been different. And I was the only judge, sitting or non-sitting, who spoke out against the recall, even though some judges were against it. They did not speak out because they were afraid. Do I think it would have made a difference? Yes. So at the time, there's no right of self-defense for judges. If you're a sitting judge and you get attacked, and even if a big lie is being told about what you decided, what you did, you're not permitted to speak out. There is no right of self-defense. And contrast that with someone who's accused of murder. They go to court, they have a right to speak out and have self-defense, but judges don't. So I think that if Aaron had had the opportunity to speak up and explain what he did, and to explain the cases that the other side lied about and brought up about his quote unquote track record, that would have made a difference. I ended up being his surrogate because of this no self-defense rule. And people would say to me, well, if this judge, didn't do all this stuff, he would be speaking up. And I would say, as you just noted, there's a canon, a rule that says judges can't, or they can be disciplined. And it was poo-poo. It's like, no, we're not going for that. people speak up if they believe they've been wronged.
Mhm.
After Aaron was recalled and removed from the bench, the rule was changed. So now judges have the right of self-defense. So if they're attacked in the media, or if individuals are putting stuff out on social media, then judges can speak up. And I do want to add one other part about this is that when I was on the bench, there was not social media.
Mhm.
So today it's really hard being a state trial court judge with social media, because people, if they don't like what you've done in a case, they can just put it out on social media, misconstrue it, and it just goes crazy. It goes viral.
Mhm.
And it's very hard then to combat that. So I tell state court judges now on the bench, you better get social media savvy. You better figure out how you can respond when you get attacked, because recall is a very real thing that can just take off and happen.
So Judge Cordell, do you think that if the defendant in that case was African-American, the outcome would have been the same?
So I don't really want to spend a lot of time talking about the actual case.
Mhm.
This was the Stanford swimmer who was a freshman. And I write about a little bit in the book. Two things. I want to say, first of all, those people who knew anything about Aaron Persky, he was a judge for 13 years and in very good standing. And he had a reputation for being especially caring and compassionate for defendants of color.
Mhm.
So it's really sad that he's no longer on the bench, because he was one of those who would just do the right thing and not be swayed by the person's color. So if the defendant had been of color, I'm not sure what your question is, would he have been recalled?
Well,
that
do you
what
think
you're-
the sentence? I mean, I think that was the controversy was the sentence.
Right. Aaron Persky would not have changed the sentence at all. If they, in other words, if the Stanford swimmer had been Black,
Mhm.
he would not have changed the sentence at all. And the sentence is one I didn't disagree with. It was 6 months
Mhm.
in jail, which was recommended by probation. This young man had no prior record and he was thoroughly intoxicated. There's a lot. I don't really want to get into it, because the book, I deal with the judicial part of this, which is the recall.
Sure.
By the way, in California, a judge can be recalled for no reason at all. If you don't like what I'm wearing, get a recall petition, get enough signatures, it can go on the ballot. My recommendation in the book is that the law in California should be changed. It's fine to have recalls, but only for a reason. And the reason should be if the judge is engaged in malfeasance, misconduct, or been convicted of a serious crime. That judge should not have the right to remain on the bench for the term of that judge. And the public should have a right to hold that judge accountable by using a recall.
Okay. All right. So my last question before we start going to the public for questions, selecting jurors. And this is a place that I think in general, for folks that don't truly understand the judiciary system, and we see it from television, we know that, African-American defendants convicted by all white juries is really the bedrock of our judiciary system. And you articulated extremely well in layman terms, the racial biases within, and I had never heard this term before, the voir dire and the preemptory process that I'm sure many of us, on the Zoom call are not familiar with as well. So can you share what that means and one of your recommendations for fixing it?
Absolutely. There's a chapter in the book called Thank You for Your Service. It's all about jury duty. And I take you through a trial I actually presided over, and we stop at each phase of it. And the first part of it is jury selection. And I'll just talk jury selection. I'm just going to talk about the criminal cases. So in jury selection, you have a prosecutor and a defense attorney, and there are challenges for cause. So that if I come in and say, I don't like that defense attorney, I hate him, and I've experienced with him, well, that's for cause. You can't sit on the case because you're so biased. But then there are peremptory challenges, and these are challenges where the lawyers don't have to give a reason. In California, if it's a felony, each side gets 10 peremptory challenges. Just excuse juror number 5, and you don't have to say why. However, if one side, a lawyer says, well, wait a minute, you just dismissed 3 African-American jurors, peremptory challenges for no cause, and I think the reason you've done it is racially motivated. When that happens, the judge then turns to the prosecutor, and usually it's a prosecutor, and says, give me the reason why you dismissed those 3. And the prosecutor must give race neutral explanations, but it's up to the judge to decide if they're credible, if that's really good explanations. What judges have done historically, and these are trial court judges around the country, is never question these race neutral explanations and just say, oh, that's fine, they're out. And what I bring up is that peremptory challenges are used basically to create these all-white juries to exclude people of color. And they've been doing it for years. And I write the history of peremptory challenges. It's interesting. So this whole thing about race neutral explanation came about from a US Supreme Court case, and it was called the Batson case. And out of the result of that case, the Supreme Court said, you have to give race neutral explanations. But Thurgood Marshall, who was on the court when the Batson case was decided, said this, and he wrote this in addition to the opinion: merely allowing defendants the opportunity to challenge the racially discriminatory use of peremptory challenges in individual cases will not end the illegitimate use of the peremptory challenge. Any prosecutor can easily assert facially neutral reasons for striking a juror, and trial courts are ill-equipped to second guess those reasons. He went on to say that peremptory challenges, and this was a few years later, 3 years later, are the greatest embarrassment in the criminal justice system. So I write in the book about North Carolina, where prosecutors had a big meeting, a big conference, and part of the conference was a seminar on how to give race neutral explanations that would get past the test so you could get rid of Black jurors. And they even had a handout giving examples, of things to say, which were really based on stereotypes of Black folks. The person was glaring at me, staring at me too hard, and I felt uncomfortable. Okay, fine, race neutral. Those kinds of things. So I have a recommendation for a fix, and the fix is in California, because California, the governor signed in 2020 the Racial Justice Act, which basically the goal is to get racism out of our criminal legal system. And mind you, I don't call it a criminal justice system. We're not there yet. We don't have the justice. So how do you get this? One way is dealing with peremptory challenges. This act, this law says that judges must question, look beneath the racially neutral answers or explanations that are given, and if required, hold separate hearings in order to determine whether or not these peremptory challenges are motivated by race. So we're in the lead. No other state has done this. And I'm not clear that we've even implemented this act yet, but at least we have it on the books.
So, we sit back, and we just had this with the Arbery trial. We sit back as our community, and everybody is already expecting that, based upon what the jury looks like, what the outcome is going to be. Because as you mentioned earlier, obviously when we have common experiences, then we can better relate to, the folks that are in front of us. And so that's what happens kind of behind the curtain, these peremptory challenges, before we finally see what the final jury selection looks like. Because oftentimes we never know, why does it take so long? And they say, oh, they're doing the jury selection. So that explains why this takes so long. And sounds like there's some limitations on how many an attorney can have, but the system is not doing what it should do.
Exactly. And jury duty, jury service is so important to the integrity of our legal system. And one of the things I point out is that jurors, don't get compensated. And if they do, it's very little. In California, you get $15 a day, and not counting the first day. You don't get that. That's ridiculous. That sends a message that jurors don't matter. So I have recommendations, another teaser, I'll leave it, in the fix for what we can do about juror compensation around the country.
Absolutely. And then I do have one last question for you. And this was, we've seen on TV court shows the kind of the comical relationship between the judges and their bailiffs. And tell us a little bit about Bonita, your bailiff.
And I wish I'd sent you all a photo of her as well. Most in every court, trial courts, you get to have a bailiff, which is a law enforcement person. And in Santa Clara County, it's a sheriff, someone in the sheriff's department, a sheriff's deputy, who sits with the judge in the court and basically protects the judge, keeps order, packs a gun, and just, it's just there to keep everything calm. Benita Jones, who lives in San Jose, a San Jose State graduate, and is from LA. I think she's from Compton, was my bailiff for the entire time that I was on the bench. So we're talking 20 years of this Black woman who is a couple of years younger than I, working as a team. And we got to a point, and I write about this in the first chapter of the book, where we could just read each other without even having to say too much at all, by just kind of her look. And there were times, for example, when I had a defendant in the courtroom and he was agitated and I knew I had to sentence him and he wasn't going to be happy. And so I would kind of nod at Benita. So when it was about to issue a sentence, she would just very casually walk over, stand right beside him, let him know that she was right there. And I've seen her occasionally, she would bend down and sometimes whisper just 10 seconds, very calmly and quietly. And then I would pose a sentence and there would be no problem. And I know I've asked her, I said, what do you say to them? She said, that's all right. That's okay. Mm-hmm. So she doesn't tell me what she says to them. But she was my protector, my friend, and we still remain in touch. So I do write about her in the book, and she appears throughout the book.
Sure.
Actually.
Well, I know that. Imagine the appearance of walking into a courtroom and you see two Black women in charge of that courtroom. I mean, that has
Black lady courtroom.
There you go. Well, I want to go to some of the questions from the audience. So the first question is, I would be interested in hearing how this experience as a judge played a role in Judge Cordell's work with the community and the police department as the police auditor.
So I don't write anything in the book about police auditing because that was well before I was on the bench. But I'm going to take the first part, which is about community and being on the bench. I was a judicial activist. Now, if you say that term, generally it's a pejorative, it's negative. People think of judicial activism of judges that go rogue. They don't pay attention to judicial precedent or the rules. That's not my definition of a judicial activist. That's a bad one. The good one is anytime you get a job as a judge, because there are just a handful of these, there are only 1,600 judges in the entire state of 40 million people in the state of California. This is a real precious opportunity. And my view is every judge should be an activist judge, meaning as you're presiding over cases, but you are taking every opportunity you can to make this system better than what it is, to improve it. And I write in the book about the times I tried to change the system, sometimes successfully, sometimes not. But what hit me in the face is that systems resist change. Mm-hmm. I don't care if it's your foster care system, if it's your education system, businesses, all systems resist change. They don't want to change. So and it's true in the legal system. So when I push back to try to think outside the box, figure out things that should be done differently, I got tremendous pushback, which I write about in the book. And I say to lawyers, to judges, to everybody, it's important, I think, to push back, and when we see that systems are not performing as they should.
Absolutely. Another question is about the good times on the bench. Give us one story that was considered a good time in the work that you did as a
judge. One of the things judges do is decide if you can change your name. And I love that, being on that assignment, because you give people what they want. They want to change their name. And there were times in that assignment where I laughed. I don't guffaw. I quietly do. I keep poker face and I go into chambers and laugh, but people in the courtroom were laughing. And I had a young man come in. He was a young white guy, and name change. And all you have to do is tell me what name you want, because they file a petition and then you have to have it advertised in a little legal notices. You have to let the world know that you're changing your name. And he'd done all of that. And then they have to tell me, why do you want to change your name? So he stands up for me, and I have to give him credit for being honest. And I write about this in the book, where he said, I'm changing my name because I ran up all this debt on my credit cards with all these companies. And so I'm going to change my name and start over. So I looked at him, I said, you can't do that. You can't do, that's fraud. You can't just do that. And he says, what? Are you kidding me? I can't. So, everybody was kind of chuckling, and, he walks out despondent. But then real feel good, and I end the chapter with this, and I'll just leave it as part of the teaser, is that there were trans people, men and women, who would come in to get their names changed. And I write about the case of a trans woman who came in to have her name changed. And I would generally, this is in the 90s now, because today it's like, ain't no big deal. I took it at the end because I didn't want any embarrassment for this person. And so I did the name change. And this person then was very happy. She left the court, and the next day she sent me a letter. I got a letter, and that letter is in the book. And let me just say about the letter, the last sentence of that chapter is, it doesn't get any better than this. So I want people to read it. The backstory is, when you want to put a letter in a book that's been written to you, you can't do it unless you have the permission of the writer. So I thought, when the publisher said, you have to get permission, I said, well, wait a minute, that's my letter. She wrote it to me. In the publishing world, you have to get permission. I had to find her, and it had been 40 years, and I found her.
Wow.
And again, God bless the internet. And so I found her, called her, she remembered me, and she hesitated a little bit. And then she said, okay, I will give you permission if you will just block out, redact my last name. So her first name is Lisa. And she said, and on one other condition, and that is that you give me a signed copy of your book. I have done that. I actually met her in person and gave her the book. So that's the backstory on it.
That's great. Well, let me go to another question. Early in Judge Cordell's career on the bench, she was working with judges who lacked integrity. She called them out, drawing cartoons, and was subjected to a lot of negativity by her fellow judges. I admired her strength and willingness to advocate in an interesting way for judiciary integrity. How does she think about this now?
So thank you for raising that. It's in the book. It's in a chapter called Bad Judges. So I write about some really bad judges, but I put myself in there because I was deemed to be bad. And what I had done was draw cartoons. And I think you have a couple of them that we can show, Kemi. And the idea was this. I wasn't trying to okay, yeah, I was a little bit kind of hitting back at judges who I knew were not doing the right things on the bench. And the other part was, I like to draw. I like to do cartooning. I've always done it since I was a little kid. Can you put it back up there for me? And so, nope, one back. There you go. So I did a lot of doodling at the bench, and then I started drawing these cartoons. And then I thought, oh, wait a minute. I drew cartoons that display, you have to figure out what the legal term is. And I donated these to nonprofits, such as Legal Advocates for Children and Youth. They were put into calendars, and they sold calendars. The first year, they made $12,000 selling these calendars. So each year I did them. So the second year I did them, the cartoon on the lower right side, you see a judge, and can anybody guess what the legal term is? So the judge is holding a bottle of Johnny Walker Red. Okay, so the legal term is take the fifth. Get it? Take the fifth. So they're very concrete. So the one up on the top is Clarence Thomas, and he's holding a sign, and each of them are a bunch of sentences. It says, give me liberty or give me death. Death be not proud. Death, where is thy sting? There is whatever. And another, I can't hardly read it right now. So the legal term
time to do this.
Well, I'm going to tell you, the legal term for this one is death sentences. Got it? Death sentences. All right. So there were some judges who were very upset, particularly about the take the fifth. And it's just a generic white guy judge. I mean, that's all it is. And so a complaint was lodged against me with the disciplinary body for judges in California, the Commission on Judicial Performance. So teaser, it really went where I didn't think it was going to go. And let's just say I had to lawyer up and deal with the whole bit about drawing a cartoon.
Okay. One other question.
You can take that down, Kimmy. Thank you.
Another question is, there are people in prison today who were convicted in the past in Santa Clara County by all white juries engineered by racist DAs. What should be done to bring justice to those prisoners?
The sad truth is nothing can be done. First, the law provides that you have a right to a trial by a jury of your peers. And the definition, according to the US Supreme Court, is that peers are not people who look like you. Peers can be people who live in your community. So that's the first thing. Second, I have no doubt that in many instances, prosecutors in Santa Clara County, and that's not unique, it's throughout the country, utilize peremptory challenges to take people of color off. Why? Because they don't want, their belief is that if they have a person of color sitting in judgment of a person of color who's a defendant, then they're always going to be in that person's favor. That is not true. That is a stereotype, but that's what was utilized. It is two things. There's something called a statute of limitations, meaning a certain amount of time goes by. You can't ever appeal your case or try to get it undone. So statute of limitations long gone for folks who have undergone this process. Second, it's likely impossible to prove that indeed the peremptory challenges were racially motivated. So that's what makes their plight one where they don't really have a remedy. What we have today is the Racial Justice Act, which says we want to stop this from ever happening again.
Mm-hmm. So, Your Honor, you have a chapter in the book called The Fix. Tell us, your top two that you would recommend in that last chapter.
Sure. First of all, it's important, I think, given that I have concerns about the legal system, that I put recommendations in for changing it and for making it better. So that's what I did in The Fix. And there are many, many more things that need to be fixed. I picked the 10 that are most significant that I describe in the book. So one that comes to mind that I think is really important is that we need to change the Constitution of California, where it provides for the recall of judges, to provide that has to be for specific reasons that I mentioned earlier. And the reason I say that that's of paramount importance is that there are three legs to our democracy: the legislative, executive, and the judiciary. If any one of those legs gets pulled out, we don't have a democracy. And as all of you know, right now, our democracy is in a very fragile state. I am concerned about the attacks against judges. And my concern is that judges are now being elected to the bench by special moneyed interests who are not looking out for to apply laws equally and fairly. So I think it is important that we change the whole recall so that we don't ding judges who are exercising their discretion and doing it lawfully. Second is the judicial elections. I have a chapter in the book called Judges for Sale. I was elected to the Superior Court, so I know of what I speak. I am against judicial elections, period. It's all about money. Judicial races now can run up to the millions of dollars, and that money comes from donations from businesses, from the corporate world, and from other special moneyed interests, and from lawyers. And in my view, you cannot have an independent judiciary if judges are bought. And that's really what's happening with judicial elections. I want them completely abolished, and I want us to go to a system where there are independent nominating commissions that vet people who want to stay on the bench, who want to continue on, and those who want to come on the bench. And they are thoroughly vetted in a public process where the public has a right to look at, watch the body at work. And then these vetted people are then given over to a governor, and that the governor must pick from those that have been vetted. In California, we have something called a Jenny Commission that does this work, but the governor is not obligated to pick anybody that the Jenny Commission has vetted. And I think that should change.
Well, I will tell you, Your Honor, this has been an amazing conversation. There are so many nuggets from this conversation as well as from the book. And I encourage everyone that is listening that has not yet read the book to go out and get it, because it is a phenomenal read. I say it's no holds bar. I mean, you go at it, and just as those cartoons, characters that you created back then, you're being very clear, as to where the challenges are and things that need to be fixed. And I think that's very brave and honorable of you.
Thank you so much.
We're going to now move to breakout sessions. And so I think I'm supposed to be turning this over to Anita.
Anita Nunes, yes.
So I want to leave you with this final passage from Her Honor on the last page, 294. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believed to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary. Hopefully, neither will you. Thank you.
Well said. John?
One of the things my group talked about, and then I'm going to go into closing, was how it impacted them. Krista gave me a great little note that, people are going to plant the seeds of trees that grow and they'll never be able to sit in that shade. If you think about what we're doing today, we're creating change in our perfect union that we will probably never see. And no one knows what the impact of the judge's book is going to be, but we also don't know what the impact of you mentoring a kid is going to be. And we don't know what the impact of you writing a cartoon that's politically motivated could be, or opening a taiko drumming organization where you give people a place to be humble and grounded with the earth, or being the loud activist who shakes the trees from her pulpit about what needs to happen in housing in Los Gatos, or the mayor who takes it on the chin because she's around a bunch of people who don't appreciate that diversity as a gift, not a curse. And so all the stuff that y'all are doing is action already. And I'm just encouraging y'all to think about it and relish it as you do it. So next steps. I want to talk to y'all a little bit about ALF. For those who don't know me, my name is John Hicks. I'm the current chair. I'll be the chair for a little bit longer. And we have some things that are coming up that I want to talk to you a little bit about. So if you're still interested in stuff that's going on in ALF, please go to the ALF website. Akemi's going to add a link in the chat relatively quickly about feedback that you can give us. And we love feedback. The only way that this organization gets better is if it hears from you about how it can be better. One of the things I want to do as chair is to make sure that folks realize that this organization is for them and by them, not from us to you. So please do take a moment and fill out that survey. On January 27th, we will explore leadership for belonging. Pastor Ben McBride, who's the founder of the Empower Initiative, is going to be talking to us. There's more information about that on the website, and you'll probably see a bunch of emails. If you enjoyed listening to the judge and the fellowship that you were able to get for the last 90 minutes, I'm confident you'll get the same lovely, warm feeling later on that might lead to some more activism on your part. And then finally, on March 9th, we will learn about just transitions for climate justice with Mateo Nube. That's going to be another opportunity for us to grow and learn as a community, and I strongly recommend y'all attend. With that, I thank you for the time that you've gifted us with today. I hope everybody feels better for having met one another and listened to the judge. Thank you so much for your time. I hope to see you again soon.